Well, hello there, and thank you very much for clicking on this video today. So today, we're going back to a familiar subject, the certain Mr. Justice Johnson, who wrongly and in defiance of any justice sentenced Palestinian action activists as terrorists. And we're also going to be covering the contempt of court proceedings that is going against one of the lawyers of said activists, and how the legal profession has come out to basically condemn the judge in no shorter terms. So let's kind of just recap. So you may be aware that six Palestine action activists were accused of breaking into Elbit Systems factory in Bristol, and they were charged with causing criminal damage. In the original trial, none of the defendants were actually convicted. But unfortunately, we abolished double jeopardy, which basically means that you can't try someone for the same thing if they're found not guilty. We abolished that under, I think it was Theresa May. I could be wrong, but I believe it was under Theresa May. So now the state can, if they want to, basically keep going and going and going after someone until they get the decision that they want, essentially. And so following a retrial, the jury found four of the defendants, including a certain Charlotte Head, guilty of criminal damage. Charlotte Head was the person that the particular lawyer who has been charged with contempt represented. So they were found guilty of criminal damage. Then Mr. Justice Johnson, without telling the jury beforehand that he was going to do this, then sentenced them as terrorists. And the reason why he did that was almost certainly because when the state has brought actual terrorist charges against protesters, against people that have been involved in direct action before, juries, not always, but have very often acquitted them. And the reason they do that is because there is a principle called jury equity. And what that means is that juries are allowed to, this is perfectly legal, juries are allowed to acquit someone if convicting them goes against their moral compass, essentially. It is a very handy way to try and check the power of the state and basically allowing juries to say, we don't agree that this is even a crime. And it has been used before by juries, and people have been acquitted clearly on that basis. Not just in activism, but a few years ago, I don't know if you remember, there was this lady that was charged with breaking the laws around abortion. I don't recall exactly how long after she became pregnant that she had the abortion, but she was after the time limit, whatever it is. I don't know off the top of my head. And she was tried, and the jury acquitted her. They said, no, we don't believe that this is something that should be illegal. Essentially, they said, no, we're not doing it. And so in that case, just to add further evidence to this, Justice Johnson also did not allow the activists to explain why they took the decisions that they did. He specifically barred them from doing that, which goes against kind of basically legal principles in so much that other judges in similar cases have not done that. Activists, protesters, direct activists have been allowed to, in the past, explain why they did what they did, and it's usually because out of moral issues, like wanting to stop a genocide in Palestine, which is the reasoning that these people did the things that they did in the Elbit Systems factory. That was restricted, and it was almost certainly restricted because, again, in previous cases when people have been allowed to talk about why they did what they did, they were often found not guilty. And so we will go to Rajiv Menon. Now, Rajiv Menon was one of the lawyers in this case, and basically what he did was, during his closing speech, he reminded the jury that they could acquit based on jury equity. He reminded them that they could do that and it was perfectly legal. And then the judge basically goes after this lawyer for essentially reminding them that they could do something that was perfectly legal, and is now pursuing a contempt of court against them. So we're going to go. So to go into this a little bit further, we're going to the Legal Gazette, which is not a source I thought I would be using, but there we go. It is a good source for this particular issue. So let's go into it. So solicitors have joined forces with barristers to speak out over the contempt proceedings faced by Silk Rajiv Menon, describing the court's decision as chilling and an attack on free speech. At an event this week organised by Garden Court North, Garden Court, One Pump Court and Nexus, speakers from across the legal sector spoke about their concern about next week's High Court's proceedings. Peter Weatherby KC, who chaired the webinar, said for the first time ever in this jurisdiction, a lawyer is facing criminal trial for what he said in a closing speech to a jury. Wholly unprecedented, but in my experience not uncommon in other jurisdictions, just authoritarian ones. It represents a very dark turn of the rule of law here. So to basically get solicitors and barristers to come out and basically condemn a fellow practicer of law is pretty severe. And so we'll continue with this. So Baroness Shami Chakrabarti, the former Shadow Attorney General, also said the rule of law should protect fundamental human rights. That includes the rights to a fair trial and representation of your choice, adding, courts should be fair. It was, in my view, very crystal clear that in both of these principles, those golden rules that are part of the rule of law have been violated, graphically violated in a case for everyone to see. She then added, in recent years, we've seen so many attacks on civil liberties, on lawyers, on judges, on the rule of law, but normally they've come from the executive. How more difficult, unsettling and delicate to handle when threats come from within the judiciary itself. It is my view that judges have behaved capriciously in this case in a very chilling manner. Saying it, then continuing, if there is no rule of law, there is no right for a fair trial if lawyers are treated in this way. Which is exactly the point. Lawyers have, especially lawyers that act in defence, have leeway to advocate vigorously for their client. And that is what this guy did. And he just reminded the jury that they were allowed to do something that is perfectly legal. The principle of jury equity is perfectly legal. It happens all the time. And it's perfectly fine. And the fact that he's basically being pursued by a judge, I call him a corrupt judge because this judge was asked to recuse himself at the beginning of the case. He was asked by the defence because this judge had previously worked for and has links to the defence industry and defence contractors. So, not unsurprisingly, the defence thought, this guy's probably not going to be terribly fair and going to be sympathetic to the prosecution and the defence contractors. So, continuing on with this, the Criminal Bar Association chair, Real Carmi Jones, KC, alluded to the number of tales of barristers across different parts of the country that we have heard of, barristers changing their speeches or being told to change them, including in cases where no direction has been given by a judge. That really can't be ignored. People at the criminal bar have become uncertain and scared of what they can and can't say, scared that somehow they might be, at the end of the trial, where they have faithfully represented their client themselves, facing a criminal contempt and also through some unknown and novel procedure. What is a really enormous concern is now impacting how criminal barristers feel able to do their job and how well they do it. So Solicitor Raju Bhatt, founder of the Bat Murphy, described the contempt proceedings brought against Menon as wholly unjustified and an unprecedented attack. He added that the proceedings were an attack on the jury system on which this client of Rajiv's, this particular defendant, sought to rely. The right of juries to give their verdict according to their convictions. What Rajiv did here was nothing more and nothing less than the job he was required to do for his clients in accordance with his duties and the pursuit of the rule of law. Solicitor Jane Dayton of DPG, who has previously instructed Menon, described the criminal proceedings against him as Kafkaesque. Menon said that he had been completely overwhelmed and humbled by enormous support he had received from lawyers, non-lawyers, and complete strangers. So that is what the kind of legal profession has said. Other kind of legal voices have also in the past talked about this. But let's make one thing clear. This is an unprecedented attack coming from the judiciary itself, against the right of lawyers to say what they need to say to defend their clients, the right of a person to basically execute a meaningful defense against the state, and an unprecedented attack on freedom of speech. And I would like to thank organizations like Defend Our Juries, who have been campaigning relentlessly on this issue, and indeed other issues where some of they have protested outside courts. In this particular case and in other cases, there's a reminder that juries have a right to find defendants not guilty based on their moral convictions. And several of those protesters have been attacked themselves, not physically attacked, but the Crown Prosecution Service has basically tried to pursue criminal cases against them. They've not succeeded. My understanding is that they've not succeeded because in one particular case, a judge pointed out that you can't prosecute someone for pointing out something that the jury is legally allowed to do. That's not a crime. So we can see through the Crown Prosecution Service and this particular judge how, as I have said, the rights of defendants is being kind of squeezed and crushed. And what is more disturbing is will other judges take this direction, go in this direction, and become much more draconian, and then start to really restrict what defendants, particularly defendants who are involved in cases like this, can say, and what their lawyers can say, and essentially making it show trials. It's a serious concern. And this is why I followed this particular story as much as I have. I've made several videos about it now, and this one probably won't be the last, I'm sure. But anyway, thank you very much for joining me on this little side quest today, and I will catch you in the next video. So thank you very much for listening, and you have a good day. Bye bye.